Good evening, everyone. Thank you for joining me in this beautiful morning. Just kidding. It's not morning. At just typing. It is freezing. It's like 20, 30 degrees right now. But tomorrow's gonna get cold and it's supposed to snow. I don't know when, but thank you that one person's here. I appreciate it for being here. Thank you for liking. If you're new, also subscribe. Just smoking cannabis. Cannabis is the best. Some people don't like it, but it's a beautiful morning. No, it's not morning. I'm just joking. Just chilling, guys, with you guys. Luke, and subscribe. How you doing, J-Man? How was your evening? Mine's alright. Yeah, just had my MRI results. I didn't get my MRI results today, but I'll probably get next week, sometime next week. I ain't doing doctor virtual. Don't forget to hit that like button and subscribe. How you doing, Leighton? Just chilling. I'm at just chilling. I'm at 830 subscribers right now. What happened? Why are you in the hospital? That sucks. You're in the hospital. I hope you feel better. Hope that you feel better. Hi, Sean B. Let's see. Oh, that sucks.
No, Ms. Walsh is not officially on this case. She was on the computer case that was no process.
Yeah, okay, great. All right, we're here now to address the state of Florida versus Portland County. The president says the state on Agriculture and
Just watching some true crime here.
creative as well as planning who is present in court. And I'll turn it over to the defense.
Sure, Judge. Just to kind of update the court, we have pending a motion to dismiss. We have pending a motion for reconsideration of bond, which we filed a second amended motion recently.
But if the case gets dismissed, then you don't need bond.
The information.
That makes no
We have a
sense.
motion to suppress surreptitious recordings. We have a motion to compel 404 evidence. And we have a motion to eliminate concerning the CGI.
Sean B, do me a favor. Oh, yep. I didn't even have to ask. I was about to ask that. Thank you.
The only one that has been
Sean B's the
responded to
best.
in writing, which was last night at, I think, roughly 7 p.m., was a response by the state, which I have not reviewed, the motion to dismiss. All other motions have not been responded to in writing at all, and my communication attempts with the state have fell on deaf ears until yesterday. I had not heard from them in probably about 30 days, despite repeated emails. I know Mr. Avalon was in that point the case and then out. I do understand that, and out for the holidays.
Everyone, don't forget to hit that like and subscribe button, guys. It helps a brother out.
Again, I know it appears Mr. Avalon may be in trial on Monday, depending on what the defendant ultimately decides, but you know, as we used to be called fungible to a certain extent, you know, there's multiple state attorneys who are on this case.
You saw that McDonald's came out with the Grinch, the Grinch meal.
Motion, but we've been asking for over 60 days and it's gone unresponded to. If they can just please have their witness update the addresses of all the civilian witnesses to make sure that, you know, in moving forward and serving them for depositions, that we're
How you
not
doing, Sean?
chasing
How you doing, Sean B?
around the country. So, again, Mr. Avalon, last night, in his very professional response, indicated that he's aware that these things need to get responded to, and he's
Can you get the guys here where I'm listening to?
efforts to make that happen. But at this point, we're asking for some hard dates for the state to reply, and especially hearing date. I think the most paramount one in the defense's mind is the motion for reconsideration of bond. So I would ask, I'm asking for dates, response dates for all of these, but
I'm just asking if you can hear what I'm listening to.
sufficient amount of time to
So
respond.
it's too low.
And to set hearing on that.
Okay. Is that it? Before I turn it over to the state? I mean, I can.
I can't read my own handwriting,
Yeah.
but, I mean, these, yeah, but, I mean, that's where we're at.
Okay, so one thing I want to ask before I let you just respond in whatever way you wish is, I would like to think that you.
All right, I'm just asking because sometimes YouTube be acting fucking funny.
The addresses of witnesses.
Yes,
What's the
Judge.
status of that?
So Judge, I can tell you that the most that they've done.
And the judge in this case, she's kind of attractive too.
Telephonic contact with them.
They being the victim witness.
My victim witness counselors. So and I apologize because we need to do more than just that, obviously. So I made a note for myself, as soon as I go back today, that's the first thing I'm gonna tell them to do is confirm everybody's address one way or the other. Just so that I can get that to them hopefully by Monday.
Well, and I'm going to put a deadline on that for the next Friday.
But nobody should be waiting trial 3 years.
All listed witnesses, that's certainly, I know that discovery tends to be an evolving process, but if there's something new arises, then this wouldn't be applicable, but any witnesses who are already on the witness list, you
Her name Adriana Ricker
Yes, Judge.
Wolferson.
Now, do you intend to file responses in writing?
And Courtney Clenny's, she looks different.
Motions other than the motion to dismiss it, you've already filed.
Yes, Judge. So not
She
in
lost a
any
lot of
particular
weight.
Order, but I have
And she hasn't been
I guess,
eating.
a request or a question for the defense. One of their motions is
Some
to
people don't
add
eat when they're in
a
prison.
CGI video. I have not seen this video. I'm not sure if it's been created yet. It's hard for me to object to it or even.
And some people do. It depends on your mental health as well.
Sure, Judge, it's a kind of a-
Probably me, I'll starve myself if I was in prison.
More so to the
I
court.
probably wouldn't eat. But you don't know until you are in that predicament.
Together, but it was more of a preliminary, before we finalize anything with the CGI people, it's more of a base request, with regard to the admissibility as a demonstrative aid versus evidence. It's not, obviously it's evidence-based, but it's
Your
very,
intention would be for it to be a demonstrative.
correct.
Yeah.
Right, yeah.
The defense is basically arguing now that the cops told the guy to delete video that could probably help her.
But it's definitely demonstrative. So it's kind of a pretrial, that's why you named it motion limiting.
With these cases, cops need to do better.
Complete. They've been working on it, but we just, before we go ahead and finalize the video, and obviously that's, the court's ruling on this pending motion limiting could change depending on, obviously, the expert witness testimony that would be presented, but we want to have kind of a direction before we go through the expenses of finalizing the actual video itself.
So I guess what I would want to have happen is if you have like a general idea or an example of something that has been created in some other similar litigation.
Yeah, no, absolutely, it's the company, I'm sorry to cut you off.
Yeah, no, that's what I would need to say, okay, what are we even,
Sure.
there in front of me.
The company is 3D Forensics. They have a 100% admissibility rate as far as being able to show they've never been denied. And we have samples of what
Oh,
they've
thank you
done
when I
and
see her.
The resume of the engineers that developed this technology and whatnot. So yes, we have all of that we can provide.
I think that would be helpful.
Certainly helpful, Judge, but, the hard part about it is this comes
I
down,
don't know.
especially for demonstrative purposes, a decision by the court. And it'll come down to the prejudicial effect of what this video actually shows. So,
So in general terms, if you provided an example of something that has been used in a similar litigation, which I'm sure, you didn't just come up with this out of thin air, obviously this exists, right? So I would need to see that type of an example, then I think you would have to explain to both Mr. Aguilar and the court how you see and envision that playing out in reference to Ms. Clenny's case.
Sure.
That way then I could rule on a legal matter, say, okay, so yes, no, or a different
Right.
route, and then create the actual video for a final ruling at some point.
Right, absolutely. I think it's going to be subject to a final ruling and testimony by the experts as far as how the court's going to rule on that. But yeah, Judge, they've done
How you
everything
doing,
from
Jiggy?
civil litigation, reenactment, vehicle collisions for personal injury cases to actual police
So you
shootings. It's all
remember
based on
me?
video, and then being able to
I don't
get
remember the
points
name,
of
no.
reference, and then they do their fancy engineering stuff to it.
Which
But
is what the problem would be, right, the fancy engineering.
well, what this is, which is why this is, well, it's not different, but they used the raw data from the Faro scans that were done at the apartment to produce the scene.
Got it.
So that part clearly
Dancing around
can't be
in next
contested.
I'm sorry, I didn't speak over you.
That's okay.
We're way far ahead of ourselves at this point.
Sure.
I think that I won't require necessarily the state to file a response unless we're able to provide some sort of examples of how this would.
Don't forget to hit that like and subscribe button, everyone.
We can
That
take
to me
that.
is, yeah, that's way.
I'm at 830 subscribers right now.
In the future. What about the motion for reconsideration of bond, which I agree with Mr. Prieto would probably be something we would do as a threshold matter? Are you going to file a response?
I am, Judge. That's the next one I'm going to work on. So this is a third request of the defense for a bond. First, was the Arthur hearing, then there was another hearing for reconsideration based off of a medical examiner listed as well as a knife throwing expert. And now there is a secondary witness which has not been listed yet. That is the grounds for this one. So the only issue with my response is they have provided this person's report. I don't know if they intend to list this person or intend to actually use them, but I do need to depose them. So it's hard to say, outside of just writing off of their report, what it is that I would respond to. So.
Yeah, Judge, I don't see why the state would need to depose this expert witness. It's an expert medical examiner from Hillsborough County that in the collateral civil case testified to matters pertinent to basically arguments that were made at the Arthur hearing by the
Oh, she got
state.
sued.
Argument at the Arthur hearing, quite honestly, and it wasn't Mr. Abrahoff, but a timeline where they're in the state's mind, right, as charging this as a manslaughter, the depraved mind, charged as a second, right, the depraved mind aspect of it, which was the third element of what the state has to prove for. And so they claimed that Ms. Clenny allowed the alleged victim in this case to bleed out basically 13 to 14 minutes prior to calling 911. This expert, the defense's argument was no, she called 911 right away. The phone records show, right, that she called 911 at this, anyway, I'm getting into the minutiae.
Is there a transcript of the testimony?
If you're defending yourself,
There is in the collateral civil matter, there absolutely is.
you do not have to save somebody's life. But I guess in Florida you do.
It would cost me an arm and a leg, but sure, I could have the lawyer's deposition.
I mean, I think that at some point in the future, they're going to want to.
I guess in Florida, if you stab somebody,
And I'm not saying they have.
I guess you gotta save them too.
Don't get me wrong, but what I'm saying is, in order for the state to be able to respond, because that is one of the bases that you have put forth, then he needs to know what this person is going to say.
Right, I attached a very detailed expert report as an exhibit to the motion, where Dr. Webb's, Malad Webb, details his findings, the basis of his findings. He refers to all the sources that he used to find it. All those opinions are contained in that expert report.
Okay,
So that's been provided to the state.
all right. How long do you need to file a response?
So again, so it depends on this trial. If this trial goes on Monday, I anticipate the trial will be finished Thursday or Friday. We have a probation hearing that I don't think is going to go on Friday. It should be out. So in theory, I can start working on this either Friday or the following Monday.
Okay.
But I need to depose him. If I am provided this deposition, I don't need to depose him. I know what he's going to testify to. So the problem is a report is going to be a summary of what this person believes in.
I'm not going to have that. I'm not going to delay for a deposition for you to be able to respond. I think you can respond with you.
Okay.
And Judge, I did speak to Mr. Abrahoff, and I told him, look, the gist of the report, and obviously look at yourself. This medical examiner determines, based on his review of and expert, I believe qualifies as an expert, but he says that the injury occurred more likely than not, to his degree of medical certainty, that Ms. Clenny called 911 immediately after the injury.
Okay. Let me ask you this, Mr. Perry. When you talk about the fact
The video shows that she called 911.
is that something that you are asking this court to do before we take a 2-week break during the holidays? In other words, does that have to happen before the 19th of December, or could it happen before January 5th?
Judge, I have to refer to the court, and Mr. Abrahoff is entitled to respond, so I'll defer to the court and the state on this. I mean, but obviously.
I'll be back, guys, later. Thank you for joining me.
Delay,
I'll probably be back in like 10 minutes. Thank you.
And